couple things strike me as I read that quote. One is, there is a transcendent source for law. He says, God is the author of justice. You know, if we're going to look for what is just, or what's right, or what law is, we have to look outside of our human experience to God. Notice how right and law and justice are totally intertwined with each other. And I'm really struck by his definition of law. Law signifies a rightful warrant. Not just any warrant. Law is not just whatever the government says or whatever the king commands. It's got to be a rightful warrant. Enjoining what is honest, forbidding the contrary. And that may not sound that surprising, but we're going to see that there are viewpoints today that totally disagree with this. That law, for it to be law, if we're going to say something is truly law, it has to, the content of it matters. The content has to be just for it to truly be law. So that's Bracton writing in the 1200s. Jump ahead now 350 years. Reformation has taken place. Renaissance. Black Death has come and gone. Many different generations of kings and queens. To Sir Edward Coke. Cook's an amazing guy. He was a great legal thinker of his day in the early 1600s and late 1500s. One of the best resumes I've ever heard of. He was the Chief Justice of both the Common Pleas and the King's Bench at different points in his time. He was the Solicitor General, Attorney General, Speaker of the House. I mean, he was an amazing guy, an amazing writer. And he's also the guy who, kind of in his day, rivaled West Publishing Company in putting together the reports of cases that were decided in England. And I want to point you to a particular case called Calvin's case. And I'll give you a brief introduction to it. It's a case in which a guy named Calvin, who was from Scotland, had wanted to sue two people who were in England. And the defense was, he can't do that because he's not English. There's no jurisdiction over him. And so the whole question was, does Calvin owe what was known as allegiance, or we would call it allegiance, to the King of England at the time? And Cook decides this case by turning to something called the law of nature. And I want you to read about what he says, and then I'll briefly describe it. So again, very similar to Bracton, although he's writing hundreds of years after Bracton. He believes that there is an external standard, there is a standard of right and wrong. He calls it the law of nature, that God infused into us at the beginning of creation. And here's what's important, well, I think it would all be important, but the law of nature is part of the law of England. It is immutable. So it can't be changed, and it actually matters to us in our court system today. And what I always am amazed by in Calvin's case is that there wasn't any positive law that he could turn to decide this allegiance question. He turned to the law of nature to say, well, of course he owes this duty. By nature, Calvin owes this duty to the King of England, and therefore the outcome of the case is there is jurisdiction. And so, not just a theoretical matter, he's using the law of nature to decide an actual case in England, 1610.
When he says part, the law of nature is part of the law of England, was he assuming that there are other elements that affect the law of England other than the law of nature? Okay.
Yes, so that there might be some specific things that deal with importing or exporting in England, or specific taxation laws that are unique to England. Those would be part of the law of nature that are true everywhere, every place, at all times, but these would be a part of it.
Speed limit on horses.
Exactly.
Mal in se versus mal prohibited.
Yeah, that's right.
So is he also saying that there is no distinction between higher law and common law at that point?
Well, I don't think he'd be saying there's no distinction between it at all, but that principles of the higher law are part of the common law. Not that all of the common law would have been higher law, but the higher law was part of it. So if I had a Venn diagram, the bigger category would be common law. All right, now jump ahead one more time to this great-looking man. William Blackstone wrote in the late 1700s. So again, we're jumping ahead, and now the common law at this point is pretty mature. Blackstone writes in the late 1700s, when the common law has developed over many, many years. Most people don't believe Blackstone was a brilliant innovator, but he was a great summarizer of what the law was. And very influential in this country, Abraham Lincoln, and really most people who learned the law before the Civil War would have learned it from Blackstone and reading Blackstone's commentaries on the laws of England. So we're 500 years after Bracton. What are people saying about law about a transcendent source for law? So again, he, like Cook, talks about something called the law of nature. I didn't put on there, he starts out this quote by saying the law of nature being coeval, or being of the same, coming from the same time with mankind and dictated by God himself, is of course superior. So he says God's the source of this. It exists, it's binding at all places, all times, and it matters. It matters to human law because if there's human law that contradicts it, it's not valid. So just like Bracton, just because something shows up in the law books, or just because the king says you must do this, that doesn't mean it's law. Human law has to not be in contradiction to this higher law, this law of nature. Now, of course, I'm just giving you a few quotes over hundreds of years, but it's to give you a taste of what I believe is the dominant view, that the main legal thinkers at the common law time believed in something like this. They believed that there was this standard of a transcendent source for law. Now, I think a big question, though, is, okay, maybe they wrote that way, but did it matter? And so I want to turn to maybe part B, I think, if you're following along on the outline, which is, does this matter for human law? Did it matter to the common law? If we believed that there was such a thing, did it shape the law in any way? And I'm going to argue that I think the belief that there was a higher law mattered to the development of the rule of law, to the development of constitutionalism in the Western legal tradition, to the protection of liberties that we take for granted today that are basic to us, in many ways are shaped by this viewpoint and this tradition. And I want to go back to Bracton again. Well, actually, before I do that, let's talk real quick. When I say the rule of law, it's something that we talk about it all the time. You hear the rule of law, the rule of law. How do you understand the rule of law? What does that mean?
In contrast to the rule of men.
Okay? Yeah. So it's in contrast to the rule of men. Yes?
Well, it would seem to me that it would apply to all persons in the same way.
Okay. So a certain equality of how the law, quality of treatment, how the law applies.
I sort of see it as the rule of mob versus the rule of law.
Okay.
The mob gets to decide versus the law. I hang somebody because we all agree to hang them.
Okay. Yeah.
So I am anarchy.
Mm-hmm. And sort of going along with, is it a rule of men, whether it's a dictator, for example, or a majority or a mob? It's sort of, what's the ultimate authority? Is it going to be human beings, people, or is it law? What's the ultimate source of authority? People or law?
Something outside of people that constrains
That's right.
power.
Yes.
And it involves predictable principles that can be articulated, that you can derive concept from.
Yes, that's right. So there's predictability. We can count on the law being a certain thing. It's the basis for behavior and equality. That all people are under the law, including our rulers. That even the rulers are to be held under the law. And here's an early statement from the common law that was written in the 1200s, probably the 1250s, from Henry Bracton. But it's foundational to the common law, and this statement keeps being brought back as a means of controlling royal power over time. And I take this from a longer discussion where Bracton's talking about how important the king is. The king is powerful. The king's the most powerful human being in the realm, but there's a limitation on the king's power, and it says the king himself ought not to be subject to man, but subject to God and the law, for the law makes the king. And so that the law is actually over the king of England himself. Now, there was historical precedent for what Bracton was talking about, and that was a few years before, in the early 1200s, there was this king. And even if you maybe you're thinking, I'm not really up on my royal history, you know this king if you studied the book or ever read the book Robin Hood. This is evil, bad King John. John, he really was a bad king. He was very authoritarian. He was involved in some expensive wars, usually involving France, coerced money from the large landowners in this country. He didn't go through the normal process of gaining consent for taxation. He was known to rape or seduce and rape the wives and daughters of large landowners in the country. My favorite description from a historian about King John is that he was known to be repulsive, even by 13th century standards. Description of King John. Well, at a place called Runnymede in 1215, many of you probably know this story, a group of landowners said, that's enough. We're not going to have this. We're not going to have these arbitrary actions that are against the law of England and against higher law. And they forced King John to sign the document that's pictured here, Magna Carta. These landowners came, led by the Archbishop of Canterbury, and said to John, look, you must sign this document, or you will no longer be king over England. And he signed. He did it under protest. And kings after him protested this and alleged this is not lawful, I am not bound by this. But at every point in English history, Magna Carta is reaffirmed. Now, part of Magna Carta, if you read it today, it sounds really old-timey. There's discussions about people taking corn from each other, or the king taking wood for castles. But throughout, there's a principle of, well, limitation on the king's power. That the king can't take wood for castles unless he's either given payment for it or gotten the permission of the owner of the wood. Then there are also very broad statements like this one. I'll let you read it for a second. So you recognize this as similar to something in our Constitution today. Which would be what?
Jury trial.
Okay, there's definitely a reference to jury trial. There's even a more clear description in Magna Carta about the right to be tried by one's peers. What else? Yeah, I look at this and I say, wow, doesn't that sound a lot like the Fifth Amendment?
Yeah.
Or the 14th Amendment? And there is no doubt that historically, our commitment to due process is really taken from England's commitment to due process, stemming back to this point. Not that, and I guess I should say free men, initially this just applied to free men. But within 100 years it applied to all men, eventually it's applied to all men and women, all persons within England. The key is that it's not that nobody can ever have their life taken away or have their property disseized, meaning property taken away from them, dispossessed. That people can't be imprisoned. Those things did happen and could happen, but only if it were done by the law, through the law. There had to be due process of law, or the law of the land. And so, very strong statement. And again, there are others who later try to get out of this. Edward I is one of the first people who says, look, I don't want anything to do with this. I am not bound by Magna Carta. And if you're thinking again, I don't know Edward I. You do if you know Braveheart. He's Edward Longshanks, who's referred to in that movie. Tries to get around it. He's forced to sign it. The biggest challenge, though, came, I think, in the 17th century. And I won't go in depth into this, but this is a picture of Charles I. He's James I's son. Really interesting period of English history that I think can be